Hello, everyone. Welcome to our commercial litigation webinar, The Impact of Tariffs on Common Commercial Contractual Provisions. My name is Kim Potter. I'm a partner in Fasken's Litigation and Dispute Resolution Department in our Toronto office. My practice focuses on commercial litigation, including complex contractual disputes, professional negligence claims, and shareholder disputes. While I introduce my other litigation colleagues, please see the administrative logistics that are outlined on your screen. I'd like to draw your attention to the survey and CPD certificate points. Links and information will be available at the end of the seminar for you to receive your Ontario, Quebec, or BC certificate today. We'd also appreciate it if you take a minute to fill out the survey as well. Joining us today are Lars Brusven. He's a partner located in our Vancouver office. Lars is a commercial litigator with a focus on contract disputes, shareholder fights and oppression remedy claims, professional liability investigations, fraud proceedings, and class actions. Sébastien Richemont is a partner from our Montreal office. Sébastien is a seasoned litigator within the Litigation and Dispute Resolution Group in Montreal. His main areas of practice are class actions, shareholder disputes, arbitration, manufacturers and professional liability, contractual litigation, and security matters. Last but certainly not least, we have David Ziegler, who's a partner in our Toronto office. David's robust civil litigation and arbitration practice encompasses business-critical commercial and financial disputes, class actions, product liability matters, and disputes requiring international arbitration. His vast experience acting for both Canada and US-based companies is sought after for domestic and cross-border disputes spanning a broad range of industries. Now I'll turn over to David.
Great. Thanks, Kim. So I'm going to start this webinar off with some brief comments on pricing and delivery terms before we move on to some of the other common contractual clauses that may be relevant in the world of tariffs. So for many agreements, particularly supply or distribution agreements or certain construction agreements, companies considering the impact of tariffs on their business first need to look at these key terms. In nearly all contracts, the delivery terms will specify who is responsible, and parties should be able to obtain a relatively clear picture of their position from those terms. For cross-border contracts in particular, parties will often incorporate the standardized international commercial terms, which are otherwise known as the INCO terms, and those will often specify who is responsible for tariffs. Common INCO terms such as free on board or FOB would allocate responsibility for tariffs to the importer, while common INCO terms such as DDP or delivered duty paid would allocate responsibility to the exporter. But determining contractual responsibility is only the first part of any analysis of the impact of tariffs. To really figure out the impact, you need to consider how pricing and delivery terms are actually structured. Are they fixed? Do they contain some flexibility? And that flexibility can take a wide range of forms. Some contracts contain clauses that permit parties to amend the terms when certain conditions are met. Other contracts automatically adjust prices in accordance with the cost of materials or other related items, such as they could be tied to an industry benchmark or something of that sort. And yet other contracts provide parties with some leeway on the volume or quantity of goods to be shipped. It's particularly meaningful in this world whether there are minimum purchase or supply commitments, as that determines the scope and the extent of any party's obligation going forward. Now, I suppose in addition, if a party is not an exclusive distributor or supplier, not in an exclusive distributorship or supply arrangement, that party may not have any obligation to do anything going forward, which makes things rather simple. But ultimately, the first step in any analysis of the impact of tariffs on a contract is examining those critical provisions, who is responsible, and what the impact may be. Now, moving on to the next slide. What we've recently seen with the new tariffs and the ever-changing tariffs has provided some key lessons for future contracts that parties and companies are contemplating. Now, obviously, the most important lesson we've learned to date is try and allocate responsibility for tariffs to your counterparty as much as possible. But obviously, that won't be feasible in a large number of cases. So instead, we see parties trying to reach some compromise to lessen the risk of tariffs. And there are a number of different ways to accomplish this. Can you get your counterparty to agree to reimburse a portion of future tariff-related costs through an indemnity provision or the like? Can you build in greater flexibility into the contract by including tariff-specific price adjustment clauses? For example, you could build in a price escalation clause tied to the cost of specific materials that matter for your contractor down the line. Now, if a counterparty is just simply unwilling to compromise and won't take on any risk of tariffs, you need to consider, or companies need to consider, simply taking on less risk themselves. And the smoothest way to accomplish that is to use shorter contract terms. Don't lock yourself into an arrangement for years, work in months. Now, obviously, that comes with its own downside risks and problems, and that's why longer contractual terms create greater certainty and can be preferable. But in this world, that's not always the case. Now, another way to build in flexibility into your contract is to negotiate lower or non-existent minimum commitments. Again, make sure you aren't locked into a situation that could suddenly become untenable because of a random executive order somewhere. Now, turning back to the impact of tariffs on existing contracts, and my slides are held up briefly. Perfect. There are a number of other meaningful contractual clauses that can mitigate the impact of tariffs, and I'll touch on just a couple before turning it over to Lars. So one common provision is a change in law provision. And now these provisions typically permit parties to adjust specific terms of a contract when a change in law has occurred that impacts the contract in some manner. And a very basic example of one of these clauses might read, contract price shall be adjusted to take into account any increase or decrease in cost resulting from a change in law. But of course, the analysis of that clause doesn't stop there. The crucial question when looking at your change in law provision is, how is law defined in the contract? And a second question is, does the change in law provision contemplate changes in regulations or other government action in addition to laws? What changes are actually listed in that clause? For if a change in law clause only refers to changes in law, but not anything else, such as governmental decrees, regulations, executive orders, or some other related means of changing law, the law is defined narrowly in the contract, or the law is defined narrowly in the contract, or isn't defined at all, it's likely going to be very difficult to argue that it's triggered by contracts, by tariffs. And ultimately, that note on the slide is key. The language of the clause is key. What does it say? What does it cover? What is its scope? You really do need something expressly bringing it in to the world of tariffs for it to actually apply in such circumstances. A second term to consider in your contracts, and this term often arises in cross-border contracts that have incorporated the Incoterms. It's not an Incoterm itself, but it tends to be used in those types of contracts that do use Incoterms, is a hardship clause. Now, a hardship clause is similar to many other types of clauses. It permits parties to pause performance where a contract has become significantly more onerous for one party to perform. Now, the principles that apply to hardship clauses are very similar to those that apply to force majeure provisions. And I understand Lars will be delving into that. So at this point, I'll defer to him now on that front.
Thanks, David. I'm going to be speaking on the issue of force majeure clauses, which have become fairly in vogue in the Trump tariff era. And I think it's worth a refresher on what these clauses offer and what they do not. So just by way of kind of brief overview of force majeure, they're, of course, a contractual clause that excuses performance in the face of an uncontrollable event. These clauses are intended to expressly allocate risk for intervening events that affect parties in the performance of their contractual obligations. Now, in common law jurisdictions, force majeure clauses must be expressly incorporated into the contract. This is not something a party can rely on the basis of a common law doctrine if it's not set out expressly in the contract itself. Now, you'll probably be familiar with language that comes from force majeure clauses, and these typically refer to things such as acts of God, fire, flood, earthquake, storm, natural disaster, war, terrorism, invasion, or insurrection. Now, of course, after the COVID-19 pandemic, force majeure clauses also incorporated events such as epidemic, pandemic, or quarantine restrictions. Force majeure clauses often contemplate a time period in the case that a party is delayed from fulfilling their contractual obligations, but not necessarily rendered completely unable to immediately. These clauses will often have a set period, 30, 60, 90 days. And if a force majeure event, once invoked, continues beyond that period, either party may terminate the contract on the basis of that force majeure event. Other typical characteristics of force majeure clauses, they almost always state that it's an event that's beyond control of the parties for obvious reasons. They require that notice is given, and that they will require either that it makes performance of the contract impossible or causes a delay to performance. But importantly, a force majeure clause is up to the parties to customize to their needs. So as we'll get into in a few minutes, the drafting of these clauses can be very consequential for how they're interpreted and ultimately applied by courts in the face of a dispute. Finally, the last characteristic of force majeure clauses that you typically see is that a party invoking force majeure clause, usually in the cases of delay, must make efforts to mitigate the impact of that force majeure. You can't just invoke it and walk away unless you've, again, kind of set out the basis to do that in the contract. Now, force majeure is often kind of discussed alongside of the common law doctrine of frustration. So I think it's worth spending a minute just discussing the differences between force majeure and frustration, as they are quite distinct and kind of play out in materially different ways. Now, frustration of contract is a common law doctrine, and it can apply to a contractual relationship, whether it's explicitly mentioned in a contract or not. When a contract is frustrated, it's terminated. The entire contract's terminated. This is different than a force majeure clause, which, again, per the terms of that clause, can be tailored to relieve a party from a component of a contract or its contractual obligations for a period, or what have you, before ultimately relieving a party of its contractual duties overall. Now, frustration is a very high bar. It's not an easy thing to rely on. In this case, when a party is put in a situation of facing an unfavorable contract as a result of tariffs changing the anticipated prices, the Ontario Court of Appeal has confirmed recently that the doctrine of frustration requires an unforeseen situation, a supervening event that the parties had made no provision for in their contract, which was not self-induced or the fault of either party. And where there is a dispute about whether a contract has been frustrated or not, it's of course the obligation and the burden of the party relying on frustration to meet those requisite elements of frustration in court before a finding of frustration will ultimately be made. Now, kind of bringing this back around to why we're here today, thinking about these concepts in the context of tariffs and contractual relationships. If a party is put in a situation of facing kind of tariffs and a change to their anticipated kind of contract outcome as a result of changed prices, the first step that I would recommend is looking for force majeure language in the contract. That is the most straightforward exercise. You look for the specific terms, and again, in a moment, I'll kind of get into how parties have relied on those terms and some lessons from that. Now, if a contract does not have a force majeure clause, or if it does not have a clause with enumerated events that set out your situation, of course, a party can then consider whether there has been such a radical change as to take the position that frustration of contract has occurred. Now, it's important to keep in mind that frustration of contract, the doctrine itself, is not a kind of quick get out of jail free or fully relieves a party of its contractual obligations, at least not in certain Canadian jurisdictions. In British Columbia, Alberta, and Ontario, there's actually legislation that has a name along the lines of Frustrated Contracts Act or something similar. In these jurisdictions, there's actually kind of statutory protocol set out for what happens in cases where there is a finding of a frustrated contract. And according to these statutes, there's a specific path of kind of the parties needing to follow in terms of allocated risk where there's a finding of frustration. So if a seller under a contract took steps and incurred expenses to meet its obligations to kind of sell goods to a buyer, but the contract is frustrated after it incurred expenses and before those goods were sold, these statutes require that the expenses of the seller be set off as between the parties so that they kind of share the risk and the expenses that were incurred before the frustration happened. A final note on frustration and related doctrines. Again, it's very, very important to always consider the law of the jurisdiction that your contract operates under. For example, in the United States, in contracts subject to the Uniform Commercial Code, there's a similar doctrine of impracticality, which has a materially lower standard than frustration to establish. And parties can, of course, avail themselves of that if operating under the UCC. So again, always important to check the governing law under contract. Now, just a few minutes on how force majeure has been invoked by parties kind of most recently in the COVID-19 pandemic and how those disputes were kind of adjudicated by courts and some lessons that we can kind of take from that when thinking about force majeure in the era of tariffs. Again, as I kind of started off by mentioning, it's normally a straightforward exercise in the sense that you first check if you have a force majeure clause, and then you consider the enumerated events within that clause. But as we'll see, the application of force majeure clauses in the COVID-19 pandemic was kind of used by parties creatively and strategically to kind of reach advantageous outcomes, even where kind of the terms and the events on the face of the wording of the contract didn't jump out as immediately being captured by the events in question. Now, obviously, before COVID-19 happened, the force majeure clauses in many contracts did not contemplate pandemic or public health emergency, kind of events that would immediately be captured by the pandemic itself. Courts, when considering whether natural disaster would relieve a party from its contractual obligations under a force majeure clause, would often find that was not the case because the outbreak of COVID-19 itself did not actually render the parties unable to carry out their contractual duties. So what parties turned to, and most often in the case of kind of commercial landlords and tenants, was the enumerated event in most force majeure clauses of restrictive laws. Now, what commercial landlords were able to kind of avail themselves of under this term was, of course, not when the COVID-19 pandemic broke out itself or people self-isolated, but rather when governments actually imposed lockdowns and shut down businesses. This was considered by courts to meet the standard of a restrictive law that could be invoked as a force majeure event by commercial landlords to allow them to be relieved of their obligations under their contracts. Now, again, drafting is very important. There were some notable cases in Ontario during the COVID-19 pandemic, most notably one that I'm thinking of where there was a shopping mall and a commercial tenant that operated a chain of fitness centers. The landlord was found by the court to be able to rely on the restrictive law event enumerated in the force majeure clause in the contract, which relieved them from needing to provide the commercial space for the tenant. However, that same force majeure clause had language expressly setting out that lack of funds or financial ability could not be relied on by either party to invoke force majeure. So the unfortunate tenant in the situation that was not able to offer the premises to its members to work out in was not earning any revenues during the time that the gym was closed. And it sought to rely on the force majeure provision itself as restrictive laws, but the court found that the drafting of the parties kind of contemplated that the tenant would not be able to rely on its financial hardship as a result of members not being able to use the facility to relieve itself of its obligations under the contract. So the ultimate result was that the tenant was required to continue paying rent, even in the face of not being able to use the facility. Now, just to conclude, some kind of takeaways from the recent jurisprudence on force majeure clauses, and just thinking kind of in practical terms about how to use and rely on force majeure clauses or not. Kind of first and foremost, you obviously need to go to the text of the contract itself, check the enumerated clauses and whether they are or could be captured by the tariffs or the knock-on effects of tariffs. Now, as I hope I've made clear, it's merely increased costs in performing your contractual obligations is definitely not a force majeure event that a party can rely on. So thinner margins, anything along those lines is not going to meet the requisite threshold for force majeure under a contract. Another thing that's important to keep in mind is watch for language about foreseeability. Often force majeure clauses contain language about unforeseen events, which in existing contract that's been in place for a while, I think not as much of a concern. But if you are in the position of negotiating a contract these days, the foreseeability of tariffs or kind of the unpredictability of new tariffs being imposed could be something that your counterparty may argue was foreseeable in these circumstances if a dispute arises down the road. Finally, although your list of enumerated force majeure events may not expressly contemplate tariffs themselves or kind of directly related consequences of tariffs, it's important from the COVID-19 jurisprudence to think creatively about the knock-on effects of tariffs and how a party may rely on them. And for example, although tariffs might not be set out in a force majeure or standard force majeure clause that existed kind of before the current circumstances we're dealing with these days, often force majeure clauses have language that includes failure of suppliers as an intervening event. If you are in a contractual relationship and you have certain suppliers that you rely on to kind of carry out your contractual duties, if one of those suppliers is hit with supply chain issues or faces kind of trouble being able to supply you with the product that they're required to, that could be a direct line to rely on the force majeure event of failure of supplier to relieve you and your company from your contractual obligations. So don't just think about it in kind of bright line terms. Think about tariffs and then think about the knock-on consequences of those tariffs in terms of how you may rely on the clause itself to relieve your company of its obligations if that's what you wish to do. And I think with that, I will turn it over to my colleague.
Thanks, Lars. So everything David and Lars said, or most of it, also applies to Quebec, meaning that the first thing you have to look at is the term of the contracts, and obviously in Quebec as well. And I'm going to touch on force majeure and good faith, amongst other. Those obligations or those regime are also impacted by the terms the party have chosen and the intention of the parties. That being said, one of the main difference with the common law regime is that force majeure in Quebec is part of the contract unless the party decided to exclude the regime found in the Civil Code of Quebec, or had decided to modify that regime. So, in other words, even though if there's no language in the contract talking about force majeure, you have to take for granted that this would apply in Quebec. And if there is language, then you have to assume that the language in the contract supersedes what you're going to find in the Civil Code of Quebec. So I think my colleagues already covered the main takeaways about the language that you would find in the contract. I'm going rather to cover what the Civil Codes stipulates with respect to force majeure. First of all, it's a regime that excuses the person from performing its own obligation if unforeseen events make execution of the contract impossible. So there's two main conditions here. First, it has to be unforeseeable. So Lars touched the point, but here under the Article 1470 of the Civil Code, which is the article that states the force majeure regime in Quebec, it has to be an unforeseen event. There's no way around it. So, and in the current, so the first issue or speed bump I could see with respect to tariff is that tariff are known. I mean, it's not a new thing. Tariff have already been there in the past. Some contract have specific language that deals with tariffs. So for a given party to say that a tariff was totally unforeseen, that's going to be a difficult argument to make. I guess the main difference here that we have is that maybe the level of tariff we've never seen. What the Trump administration did with China at some point. I think it was over 140% of tariff. I guess that was never seen or unforeseen tariff to that level. But all this to say, that's the first criterion you have to meet, and there might be some challenges in saying that tariff are totally unforeseen in the distribution agreement. The second criteria that you have to meet in order to invoke force majeure is that it is irresistible. So it make it impossible or extremely difficult to meet your obligation. And here again, I think that in the context of tariff, that's going to be a problem, because most of the time, what tariff will do is that it make it more onerous. It's going to cost you more to deliver or cost you more to buy, but it's not impossible. And the case law on that is quite clear that a party cannot just rely on the fact that their own obligation has become more onerous to invoke a force majeure. It's not enough. You have really to be in a situation where you cannot deliver or cannot meet your obligation to invoke force majeure. Even financial hardship is not sufficient. It has to be a higher threshold than that. So all this to say, Quebec courts have generally construed force majeure as being something that's exceptional and should be interpreted narrowly and in truly exceptional circumstances. And obviously, what we've seen, the trade war that we've seen come and go as the week goes by, I mean, might look exceptional, but the reality of tariff has been part of the international business since a long time ago. And that if the party decided not to include price increase clauses and so on, the court, although they might have done in the past or other parties in the business are doing it, that might create a significant obstacle to invoke force majeure in the tariff trade war context. So last point as mentioned in the slide, the increased price is generally not irresistible, so you would not meet the second criteria of force majeure. So I'll go to the next slide then. Duty of good faith. So that begs the question. So everybody knows that in Quebec, we have good faith, which is codified in our civil code. And I would say, even though it might look like Quebec-centric, but it is not. I mean, the issue or the discussion about good faith now, I think, applies from coast to coast in Canada. In the common law provinces, we've seen that in the Callow and Waystec, the decision of the Supreme Court of Canada, the duty of good faith has been imported in common law provinces. And reading the case law, I would say that there might be slight differences between the regime, but it's quite similar. And for the purpose of today, I don't think we need to go into the weeds of any distinction there could be in Quebec or in other provinces of Canada. So good faith, we have to keep in mind that good faith is not a magic formula that lets you rewrite the contract. Generally speaking, it only requires a reasonable and loyal exercise of the party's existing right. So whatever is written in the contract, the letter of the contract, you can rely on, but up to a certain point. You cannot be unreasonable or disloyal or cheats the other party by just relying on the words of the contract. But that being said, it's quite clear that good faith is not a way to modify the contractual terms. It cannot allow a court to create new terms. And going back to tariff, I mean, obviously, the first thing you'll have to do is look what the contract says. And if the risk of increased prices or increased tariff has been clearly spelled out as being the responsibility of one of the party to the contract, good faith is not going to help you. Good faith might help you to maybe ask for a reasonable delay to the other party to adjust your supply chain, to make some adjustment to your way you're doing your business, if that doesn't cause the other parties significant harm, but it will not allow you to just change what are your obligations under the contract. So the next question is, well, if is good faith a way to open back on, in the circumstances on something that's unforeseeable? Is good faith, or would good faith require one contractant to go to the other party and say, well, we're dealing with something unprecedented. We need to sit back and review the contract. And that, I mean, we could have a whole webinar on this whole issue, but mostly you just need to go and read the Churchill Falls against Hydro-Quebec cases of the Supreme Court of Canada in 2018 to get most of the answers that can flow from that issue, whether good faith, how good faith relies or interact with unforeseeability. So just a few, I'm not going to take a lot of time on that, but in that case, I mean, there's a deal to construct a dam in Labrador between Newfoundland and Hydro-Quebec. And after a couple of years of operation, the price of electricity went through the roof. Then it's no more a public utility, but rather a commercial utility or a commercial good. And Hydro-Quebec, based on the fixed price in the contract, is making a huge profit out of it. And the other side say, well, you have a duty to come back. I mean, that's not what that's not the initial deal. You have to come back, Hydro-Quebec, and sit back and renegotiate. How are we going to share those profits? So the Supreme Court dealt with that in length. under many angles, but I think that the main takeaway is that even faced with unforeseen event, good faith will not generally allow party to require the other party to renegotiate. It's not part of the Quebec law, and I don't think this. And I'm quite sure the same reasoning would apply on in common law provinces. And once again, the court did look at the contract terms in that case, and really there was no price adjustment clause, and it was clear that Hydro-Quebec would benefit from fixed price on the electricity, so that the risk, even though it was not written in the contract, it was implicit that the risk of changes in the electricity price would be bared by the other party. And good faith as well is not or does not import hardship terms in the contract. David covered a little bit the subject, and Lars as well, but in Quebec, it's quite clear that the doctrine of unforeseeability and hardship, unless the party decided otherwise, but generally speaking, are not part of the civil law and should not be read in the contract. And good faith is not a backdoor way to allow you to import those doctrine in the Quebec contractual law. What I need to mention, though, is that, and it's not clear, I mean, some others have taken the stance that in cases of relational contracts, there might be a duty to renegotiate. I don't think that, although the dissenting judge Rowe went that way, I don't think the majority of the Supreme Court adopted that, but I think a door is left open in certain type of contract, what the Supreme Court call relational contract. And I'm going to touch the subject a little bit, but even after reading twice the judgment, it's not clear for me what exactly is captioned by a relational contract, but we'll go into that later. So just to finish my part of the presentation, especially in Quebec, and I guess that would apply in common law provinces as well, but one step that parties often fail to do when dealing with a contractual interpretation issue is go through the qualification of the contract. First, and that in Quebec is part of the civil code. I mean, some contracts are what we call nominates contract, which have their own regime in the civil code, and even case laws develop other types of what we call special contract. And those contracts can have special regimes, and sometimes you should not rely on the title of the contract. Let's say, as an example, if the title of the contract is a distribution contract, that doesn't mean that it's not another type of contract under civil law based on the qualification of the contract. So in case I was involved recently, the distribution agreement was found by the court to be a service agreement. And why that's important is that it's because those qualifications sometimes made it so that some additional duties are imposed upon the parties. So, as I mentioned in the Churchill Falls cases, the Supreme Court found that it was not a relational contract, but Justice Rowe did. And what the party said is that, well, in those cases, there's a highest degree of good faith that could involve a duty to renegotiate. So if the party qualifies the contract as a relational contract, there might be some duty to renegotiate. That being said, what is a relational contract? It begs the question. Well, the court says it's long-term contract where so it's open-ended as to the party's obligation, and sometimes even there's specific language that require the parties to cooperate or even renegotiate some terms or determine later down the road some duties of the other party. So once again, when reading your contract, you have to ask the question, well, am I within the relational contract? And if the answer is yes, there might be some open door to force the other party to sit down and renegotiate. I gave the example of a contract for services or a contract for enterprise regime. In those specific types of contract, the client has the right to terminate. And it's an absolute right unless the parties has included express language in the contract to set aside that right of the client to terminate. And obviously, in a situation where price can become an issue, the client's right to terminate might be, even though it's not written in the contract, that right obviously can let you get away from the contract. The service provider's right to terminate, there's a specific regime that very more restricted, and typically an increase in price will not allow the service provider or the entrepreneur to terminate. And there's also a price adjustment regime, a specific price adjustment regime found under when you're faced with a contract for service or a contract for enterprise. But here the takeaway is, well, take the time to determine what's the qualification of the contract and how that can impact the party's obligation. So then I'm done for now. I think Lars, you're going on.
Thanks, Sébastien. Yes, very briefly, I wanted to touch on termination clauses in commercial contracts because although the imposition of tariffs may not immediately lead to or kind of be tied to a direct termination event, you or your contractual counterparty may find yourself reviewing the ways to terminate if you find yourself in a unfavorable contract after tariffs have been imposed. Now, I think the kind of first step to cover and kind of just most important when refreshing yourself on termination clauses that there's various types of clauses with kind of corresponding various types of flexibility of those clauses and how they are applied. Now, the most flexible kind and kind of the first I'll touch on is termination for convenience. As that name suggests, it is quite flexible. Either party can invoke it, but you need to be careful when considering relying on that type of clause because in almost every contract, termination for convenience comes with a corresponding requirement to give specific notice and often payment of some type of termination fee or liquidated damages to your counterparty. Another type of termination clause is what's referred to as contingent termination. Force majeure is a type of contingent termination clause, and that's, again, as the name suggests, where an event occurs, it allows a party to terminate contract on the basis of that event. Now, even if you do not find yourself in a contract that has a helpful force majeure provision that you can rely on, it's worth reviewing your contract to consider other provisions that contemplate contingent termination, again, in the kind of specific tariff circumstances for events such as material cost changes or adverse economic circumstances. And of course, the final basis for terminating your contract is for cause when your counterparty fails to perform. Termination from cause is often set out in the contractual terms itself. Terminology setting out kind of what will constitute a material breach that allows a party to terminate. And of course, a party may rely on the common law repudiatory breach concept as well to terminate the contract. Now, if you are in a situation where you are considering exercising your contractual termination right, it's always worth, as kind of a first step, considering whether the specific contractual terms around terminating will apply more favorably to your circumstance, or whether relying on repudiation under the common law itself is a more favorable path for you to take. And obviously, parties are free to kind of set out terms that apply when relying on contractual termination clauses and kind of corresponding requirements for a party that seeks to relieve itself of the remaining contractual obligations when applying those terms. It's also important to keep in mind those specific terms that will follow, including whether if relying on the contractual termination provision, you were required to give specific notice and a form of notice to your counterparty. And again, as is often the case, whether certain types of breaches that could result in termination first allow a counterparty to cure before a contract can be fully and finally terminated. Now, if you're on the other side and you find yourself in a situation where your counterparty is looking to relieve itself of its contractual duties because of tariffs or other circumstances, and you receive a notice of termination, obviously, as a first step, consider in detail whether that notice has complied with all of the requirements under contract, including notice, form, cure provisions, and whatnot. And then it's important to kind of decide if you can, and this would be with the assistance of litigation counsel perhaps, but whether you can make strategic use of the notice, as courts have found that service of a notice of termination itself can constitute a repudiatory breach of contract. So if your counterparty is seeking to get out of the contract and serves notice, and that notice is deficient, that can actually constitute repudiation on their part, which could put you in a more advantageous position. And finally, whether you are planning to exercise your termination rights or you receive notice of your counterparty of their intent to exercise their termination rights, always, if litigation is a prospect at all, consider your mitigation obligations when a contractual relationship is coming to an end. And I think that will leave me to turn it over to David to discuss dispute resolution.
Thanks, Lars. So this is a panel of litigators, I think we'd have been remiss if we hadn't touched on dispute resolution before concluding. Now, of course, in most contracts or any contract I've seen, there's nothing specific in contracts with respect to dispute resolution and tariffs. And so the required steps are typically those and similar to those a party would take for any contractual dispute. And there, parties should first look closely at their respective contracts when considering dispute resolution to see if there are any applicable dispute resolution provisions. And such provisions often mandate management level negotiations before any litigation can be commenced, or they mandate mediation. Many these days include arbitration clauses mandating arbitration, either institutional with an arbitral body and rules, or ad hoc, following any of those other interim steps. Another clause to consider would be the choice of law and jurisdiction clauses to determine where to initiate litigation or what law would apply to any future litigation. And moving beyond the terms of the contract, there are often a number of other considerations warranted at this stage that are also not exactly tariff specific. For any party considering litigation, you need to consider your counterparty. Is it worth pursuing often costly litigation or seeking specific performance of the contract? Is that worth the cost of litigation? Does the contractual counterparty even have the requisite assets to pay a damages award if you're successful, or pay your costs if you're successful? Another consideration is jurisdiction. So if your contract doesn't have a jurisdiction clause or doesn't have an exclusive jurisdiction clause, you should consider what jurisdiction would be advantageous for any future litigation? Would a local jurisdiction be preferable? Probably lower costs for your company, but it comes with other pitfalls. Does the counterparty have assets in that jurisdiction? Would you want to instead initiate your litigation where the counterparty's headquarters is, or where they have assets so that you don't have to bring a subsequent action recognizing and enforcing any successful award or judgment? Are there any differences in law between various jurisdictions if you know what legal position you're going to take? What are the laws? Might some be preferable in certain jurisdictions? So there's just a wide variety of considerations before initiating litigation that any party should keep in mind. Most are rooted in the contract itself and the dispute resolution provision itself. It's obviously start there. But that is just a brief overview of certain considerations when embarking on considering litigation. I think now we have some time to answer any questions, and so I'll turn it back to Kim.
Thank you very much. And thanks to everyone who asked questions in advance, and we incorporated it into our presentation today. And so we encourage people to use that Q&A function to send us some questions. We'd be happy to answer them. While we're waiting for questions, I was wondering, Sébastien, if you could just touch on what kinds of remedies might be available in a context where there's been a breach of contract, and if there are unique considerations in Quebec in that regard.
Thank you, Kim. Yes, obviously the usual one. We've touched a lot about termination. I think that's obviously one way to look at it as a remedy that would solve your tariff problem. And the other one, obviously, and it's from coast to coast, are damages. But we have to keep in mind that in Quebec, specific performance is one of the preferred method of enforcing a contract. So parties would be allowed to ask for specific performance. So in one case I was involved, there was a subcontractor in a big development that was trying to run away from the site, and because they thought that it was during the COVID, the price increase and so on. And what we did, we just run to the court and got an injunction to force them to stay on the site and continue to work. So that's something that's possible in Quebec, and is not exceptional. So and on the good faith part and the duty to renegotiate, actually the Justice Rowe imposed upon Hydro-Quebec, even though it was not the ruling judgment, but he told them that, well, I order you to go back to the other party and renegotiate. So that was an example of specific performance being applied in Quebec, even though in that case that was not the ruling judgment.
Thanks, Sébastien. Another question relates to how much specificity is required for the test that the tariff be unforeseeable. So we heard Lars say that that's a necessary component of the frustration test and is often explicit in the test for force majeure, and certainly is as part of the Quebec Civil Code. So Lars, I was wondering if you could comment on how specific the knowledge of a tariff needs to be in order to meet that unforeseeability test.
Absolutely. So as you mentioned, Kim, in the doctrine of contractual frustration, it is a kind of express requirement to establish that test. It has to be unforeseen. A party seeking to rely on frustration must establish that. I think as is often the case with common law doctrines, they lend themselves to some flexibility and kind of the optics or the fairness, the perceived fairness of the dispute will kind of shape how the foreseeability is perhaps applied. But I would caution that certainly a party entering into a contract that is going into force in kind of present day would undoubtedly face an argument in response that they should have foreseen the potential for changing tariffs to impact the contract if they seek to rely on frustration. Now, in force majeure clauses, as I mentioned, force majeure clauses often incorporate language of the event needing to be unforeseen. But this is a pure matter of contractual construction. So the parties are free to use that language or not, and a court will just dive in and do an analysis of the terms of the contract itself. So if parties elect to not use language around the event being unforeseen, they are free to do so, and a court will not require foreseeability in the application of that force majeure clause.
There's a question in the chat about hardship and whether it has to be an explicit part of the contract in common law provinces or whether it'll be just part of the common law.
Thanks, Kim. I'll jump in on that. And so, what I can say is we haven't seen, at least I haven't seen hardship applied in just out of the common law context in commercial contracts. There are other areas of law where the concept of hardship comes up, where it's not specifically referenced in a document or applicable contract. But when it comes to commercial contracts, at least to date, and at least in the current jurisprudence, it seems to be the case that you do want it explicitly noted in contract before you can avail yourselves of the clause itself or of the of hardship itself to pause performance and obligations of a contract. On that note, I did want to just briefly mention a couple other considerations I had thought of while we were presenting today that didn't fit neatly into any of the topics. One consideration for those who are currently reviewing their current contracts and the impact of tariffs on those contracts, and that is to be keenly aware of notice provisions in your contract. And I know Lars touched briefly on notice in the termination context, but when it comes to all sorts of other clauses, change in law provisions, hardship provisions, force majeure provisions, and the like, many contracts, not all, I've seen many clauses that don't have this, but many contracts will include notice requirements that if you experience a force majeure event, let's say, or there has been a change in law, the clause specifically says you have 2 weeks or some other example to notify the other party of the event. And what we have seen in the case law and elsewhere is many parties losing their rights to mitigate the contract because they've not closely paid attention to the notice provisions, and they've let that lapse and they lose their rights. So again, that's just one other consideration for current contracts is make sure you're aware of all notice requirements in that contract. Then a second consideration for those who are currently drafting or negotiating or thinking of drafting and negotiating future contracts in this environment is to always be aware that there may be relief from the Canadian government if the U.S. tariffs or other macroeconomic factors get too severe. I know the government already has some loan facility up and running, and there are a couple other items for the auto industry. But if you are completing a new contract with a counterparty, keep in mind that there may be some relief coming from the federal government or the provincial governments. And if you are building in a compromise that where you share the burden of future tariffs and the uncertainty of future tariffs equally, you will certainly also want to build in some compromise so that your counterparty isn't the one getting the upside of any future government relief. So keep that in mind going forward.
Thanks, Dave, and thanks to his co-panelists. I think we've come to the end of our time today, so thanks for everyone for tuning in to this presentation. You'll see on the screen that we have information about getting your CPD credits for Ontario, Quebec, and British Columbia, and links have also been added to the audience chat for that information as well. If you don't get a chance to claim your certificate today, though, they'll be sent again next week. Really appreciate your feedback on this session. We hope it was helpful, and we hope you'll tune into our next seminar. Thanks, everybody.